back to Diamond Live. Thank you for staying tuned to the show. We are streaming live on our Facebook page, Diamond TV Zambia, but you're also watching us through DSTV, GoTV, Top Star, and Star Times on app. You're watching us on the Bing Entertainment application. That's why you should be a part of this conversation by leaving a comment or calling us on the numbers on your TV screen. Send an SMS as well, and we'll read those messages out on the show. Thank you so much for joining us.
Good evening. Thank you, and good evening, viewers.
First question, put it straight. Do you think that President Edgar Lungu is eligible to contest next year's election?
No, certainly he is not. That is a very strong view that I take personally, and that many academicians who have read the Constitution, have read the Constitutional Court judgment in the Danpule case, take that view, that he's not eligible. It's straightforward. There's no doubt about that.
I don't know if it's that straightforward, because there is still some other academicians as well that are of the considered view that the president is eligible to contest next year's election, and they're also basing it on the Constitution. They're basing it on the Concord ruling. So why do you believe that in this case he's ineligible?
Okay, let's start from the perspective of the ruling itself. And I've done this before on this show, but these are national issues, so that you can never get tired of bringing out the salient points. To start, the reason that people are basing their the views that they take, the ones that are contrary to the views that we have, is because they believe that the Constitutional Court rendered a judgment which settled the question of eligibility, but that is far from it. The issue, as I've always said before, is that the people who went before the Constitutional Court, Reverend Pule and his colleagues, asked the court to answer certain questions. And I'll read from the judgment again. The judgment is, by the way, selected judgment number 60 of 2018 in the case of Dan Pule and 4 others versus the Attorney General. This can be downloaded from the judiciary website. It's readily available. So I would encourage people to go out there and download this and read it. So I'll pick snippets of it. At J50, when the court was now considering this, what had been brought before it, it says, going by the parties' respective submissions, the main question or issue is whether President Edgar Chagwa Lungu will have served 2 full terms for the purposes of Article 1063, as read with Article 1066 of the Constitution at the expiry of his current term. The court then goes on to say at J51, before we proceed to consider the question posed above, we note that although the applicants have argued in their submissions that this matter has been brought pursuant to Article 128A, which gives the court jurisdiction to interpret constitutional provisions, the manner the above question has been couched personalizes the issue in that it targets the incumbent president as an individual. We do not encourage this trend because the framing of questions for this court's interpretation for constitutional provisions should not target any individual, as it is meant for general application, as the interpretation is binding on every person in the Republic. What we are dealing with in the present case is the office of president. We of course understand that the question is or ought to have been what it aims at, namely the office of president. Okay, but the most important part is, so the court is defining the way the applicants went through. They asked specifically the question whether President Lungu will be eligible in 2021. The court declined to deal with that question as it was put and said the question is or ought to have been framed as follows: whether in terms of Article 106, Sub-Article 3 and 6, a presidential term of office that ran from 25th January 2015 to 13th September 2016 and straddled 2 constitutional regimes can or should be considered as a full term. That is the question that was being considered. Whether this short term and should be considered a full term, which straddled 2 constitutional regimes. And ultimately, the court held at page J83, it cannot be considered a full term after giving a background. As regards the second question posed in the amended originating summons, which is whether the incumbent president is eligible for election as president in the 2021 presidential election, our view is that in light of the position we have taken as regards the first question posed in the amended originating summons, the second question has become otious, meaning that it will serve no practical purpose to deal with it, and we shall not consider it. That is the Constitutional Court, the famous Constitutional Court judgment. But now, reading that, quite clearly, the question as to whether President Lungu, His Excellency President Lungu, is eligible to stand in his individual capacity was never determined by the Constitutional Court. It refused to deal with that question. Instead, it dealt with the question as to whether or not that short term was a full term.
Now, look, I know that it doesn't specifically talk about President Edgar Lungu, but it is also true that it speaks of a figure that fits the shoes of President Edgar Lungu, because it's talking about somebody that served that period, and President Edgar Lungu served that period. It also does talk about somebody that straddled two constitutions. President Edgar Lungu straddled two different constitutions. But even in the conclusion of this particular person that straddled two constitutions, who is not President Edgar Lungu in this case, still interprets President Edgar Lungu, and it says that this person could not have served a full term.
Yes, so what does that mean? Does that mean that we then turn a blind eye to the other specific provisions of the Constitution? This is where we have a lacuna, a dark space, a grey area. In Article 106, sub-Article 3, the Constitution is very clear. A person who has twice held office as president is not eligible for election as president.
That is the 1996 is the new constitution?
This is the constitution as amended by the Constitution of Zambia Amendment Act number 2 of 2016. It provides clearly in 106.2, a person who has twice held office as president is not eligible for election as president. Very simple. Nothing more, nothing less. So, given the specific set of circumstances that we have, where the court did not specifically pronounce itself on, first of all, the specific import of sub-Article 3 in terms of holding office, the court did not determine the question as to whether a person who has been sworn in twice as president fits this category. But
the ruling did actually speak about the possibility of an individual. There is in this state possibility of an individual serving for more than 10 years, and this Constitutional Court ruling does talk about that.
In passing, yes.
And it's only possible for somebody to do that if they have been elected more than twice.
No, not exactly.
Yes, because if you are, for example, a running mate, you've been elected, and if the current president doesn't continue in their functions, and you assume then you've been elected
as vice president,
but you've assumed the position as president,
and that's where the difference comes in. Now we are talking about individuals who have been elected specifically to hold office in that capacity as president. Have a person who has twice held that office. And indeed, even if you are a running mate, I see where you're going. Even if you are a running mate and you assume office, you are holding office, you'll have to be sworn in. And there are several elements about holding office of president. Let's just assume that we are saying you can't have your cake and eat it, gentlemen. You can't say on one hand, I performed presidential duties. I rode in the presidential challenger. I used the presidential chopper. I had the instruments of power. And you say that, no. That was just me continuing a term of someone? No.
So
you can't have your cake and eat it. If you enjoy the tenets of executive power, then it follows that you held office. And then it follows for the purpose of the Constitution.
I just wanted to also understand, yes. Before Jonah comes in, is it possible to interpret the law, because in this case we're talking about two different constitution regimes, the one before the 1996 constitution, and we're also talking about the 2016 constitution that clearly indicates in Article 106 that the president can again run again. So can the law be read in totality? Can two laws be applied at once? Is it possible for that to happen? Can we apply these two laws at once? Because it seems to me that is what is happening. The 1996 Constitution says one thing on the other hand, and the 2016 Constitution also says the other.
So in interpreting any piece of legislation, including the grand norm, the constitution, one cannot apply it retrospectively. Okay? That is another key question, right, that's hanging in the balance. One cannot apply the law retrospectively unless it's expressly stated in the new piece of legislation or constitutional regime that it shall apply retrospectively. So what happens is, from the date that the date preceding the new constitutional regime or the new legislation, you will apply, you interpret the law in terms of what subsisted at the material time. Then going forward, you apply the new law. Okay, so we're dealing with a situation where was the term, not even the term, did the president hold office? For the sake of interpretation, did the president hold office during the first term?
Or was it sworn in? That is what
the question is, and it will always be. And when the time for challenging Mr. Lungu's attempt at filing his nomination comes, the question will be, did he hold office? Now, that is quite separate and distinct as to whether or not it was a full term, a half term, or a quarter term. Did he hold office? And we're
Clause 5b, the vice president or the president-elect shall serve for the unexpired term of office be deemed, for purposes of clause 3, which you are talking about, to have served a full term as president if at the date on which the president assumed office at least 3 years remain before the date of the general election, or not have served a term of office if at the date on which the president assumed office less than 3 years remain before the date of the next general election. It's specifically speaking to 1063, which is talking about holding office.
But you read at the beginning, if a person, please repeat what it says right at the beginning. Doesn't it refer specifically to a vice president?
It does.
Yes.
No. It refers to the vice president or a person elected to the office of president as a result of an election held in accordance with clause 5b.
Now, what does 5b say?
It says, let me read the whole of 5.
Yes.
When a vacancy occurs in the office of president, except under Article 81, the vice president shall immediately assume the office of president, or if the vice president is unable for a reason to assume the office of president, the speaker shall perform the executive functions except the power to make an appointment or dissolve the National Assembly, and presidential elections shall be held within 60 days after the occurrence of the vacancy. And these elections, obviously, somebody that is aside from the vice president.
So, yes, so sub-article B, which you referred to, is specific again about the vice president, isn't it? Doesn't talk about the president, does it? Sub-article 5 talks about a vacancy occurring in the office of the president, and then the vice president in A assuming office. And then in B, the speaker assumes office if the vice president is unable to do so until a presidential by-election is held. So in this instance, these facts do not apply to President Lungu as an individual. How? He has never held the office of vice president. He's never assumed office on account of the vice president failing to take office. He assumed office under the 1996 constitution, if I can call it that. By the way, it's a misnomer to call it that. It's a 1996 amendment, just like the 2016 amendment. He assumed office as a result of a direct by-election, not because he was ever vice president, when a vacancy occurred pursuant to the old constitution. So his tenure of office must be determined, let me be very clear, his tenure of office in terms of holding office pursuant to Article 1063 must be determined in accordance with the constitutional provisions which related to him assuming office.
But it's not
You can't come and bring provisions which relate to the vice president and apply them to the president retrospectively.
But what does it say about the vice president at that time that was not eligible for office? Because, of course, we do understand that Dr. Guy Scott at that particular time was not eligible for office. And these are the arguments that, of course, people bring at that particular time.
They serve? Dr. Guy Scott, by the way, had his own peculiar circumstances, which led him not to assume, to be eligible to stand, let's put it that way, in the substantive office of president. But he did assume the presidency pursuant to the provisions which allowed the vice president to do so in the old constitution. So his circumstances are completely different. But I think we need to ask ourselves an honest opinion and ask truly to what these provisions of the Constitution say. How do you apply Article 106(6) to an individual that took office on account of an election and not on account of his ascending from vice presidency?
But it does. But 6 does talk about a person that is elected to office as president as a result of an election.
No,
It
but
does.
it's
It proceeds.
very, very
It is an
I'm
election.
in
It
pursuant
says
to 106 sub article 5b,
exactly,
which
and in
begins
5
with, if the vice president is unable for any reason to assume the office of president, the speaker shall perform the executive functions except. So the key thing here is, if the vice president is unable to, for any reason, to assume office,
Which he was at that
doesn't
time,
talk-
Dr. Gaskell was
no,
unable
but
to.
you are going and applying this provision retrospectively. This provision was not there when President Lungu was assuming office.
But you
And
see
in
that-
any event, Dr. Guy Scott did, in fact, assume the office of president. Let's not forget our history. He
He
did
was acting-
assume
acting
for that
president.
90 days.
But then
he was acting, which is what that constitution provided.
in that case, then the argument of Dr. Guy Scott assuming office is also not going to be applied, because you're also applying it retrospectively.
Yeah.
Because this
No.
just like you say about President. Anyway, we've got callers, so let's engage.
Let's hear the caller.
Let's engage. Eddie
but
from
we need to be
Lola.
very, very clear on these provisions and
Who's-
not
who's-
mix and match them unnecessarily.
Good evening.
Good evening, thank you.
Thank you for joining us on Diamond Live. Welcome.
Thank you. Good evening, gentlemen.
Good evening.
evening.
Thank you.
Kwenaleke nindande kumchibemba. Therefore push not necessarily party eligibility. If the term says 5 years, therefore I must take a guide, because in the quarter kufurungana. Is there 1 year? How many years did the incumbent president hold in 2015 or so? It was 1 year, how
1
many
year, 8
months?
1 year, 8 months.
1 year, 8 months.
From January 25th.
Yes. So
2015.
in 5 years, bakateka, then plus 1 year, 8 months. So kuline, therefore to understand. Vakesa teka, is it 3 years, 2 months? Then tukakwatama elections na yambi. Ukwebati ya 2 terms ikapite, ikakumane.
Okay.
All right, to our pleasure.
Quite an important question.
All right, thank you for the question. So just before we are going to respond, you are going to respond to his question.
Yes,
but then we were talking about the issue of the Constitution, the clauses not being in place when President Edgar was running for office in 2015. But I think then the question arises on the two constitutions, on a person having straddled two constitutions. And even the Constitutional Court ruling does talk about that. It says, in this case, there was no provision specifically put in place to deal with the current president who was sitting straddling two different constitutions. And by virtue of that, it is entirely reliant on competent judges within the courts to interpret this.
Yes.
So then, does this mean this was an oversight on the part of the country in our constitution making process, considering the fact that we had a president whose term was ending in 2016, just before this constitution was assented to by President Edgar.
Interestingly, and this is not speaking to the Constitutional Court judgment, I think you ask an important question. What were the framers of the Constitution thinking in making these provisions which relate to what amounts to a full term and what does not amount to a full term? Quite obviously, in my considered view and in the view of many others, I may be wrong, I may be right, but I believe I'm right. There was in the 2016 Constitution, if I can refer to it that simply, there were certain areas that were not fully thought through. There were certain provisions that in the drafting process, I think the drafters missed out that they had made this provision in one regard and not the other provision in the other regard. But be that as it may, the Constitution must be interpreted in the manner in which it reads currently. And the manner in which it reads currently, specifically, is with regard to Article 106 3, which is the cardinal provision that everyone must keep in mind. It is very, very clear. It's unambiguous. It says a person who has twice held office is not eligible for election as president. There is nothing more or less you can take from that. And yes, I'm alive to the fact that constitutions or any piece of legislation cannot be interpreted in a vacuum. You can't pick out one clause and interpret it. But there are rules of interpretation that are applied. And in this instance, this particular provision was never specifically interpreted in terms of what amounts to holding office twice. Now, if you look at the constitutional history, and this is what is done, if the literal rule of interpretation is not used, you go to a purposive interpretation. When you go back in our constitutional history, when you look at each of the constitutional amendments that have been proposed and the constitutional regimes that have come through since the time that we came out of one-party rule, they are very, very clear that as a people we've always said no to anybody holding more than the 10 years, and we've always said no to anybody holding office for 3 terms. That is clear. And in interpreting this question in the court, when the time comes, determining whether or not this was meant to be countered by the provision regarding what amounts to a full term or not, the court will have to address its mind. Will be specifically asked to interpret in terms of what we as a people have repeatedly said through various constitutional review commissions and through preceding constitutions. And the fact
I would like
no one should hold more than 2 terms.
Just before we engage, Annie, I'd like also to just bring this to the attention. I'm just going to read part of the, this is J81, part of the Constitutional Court ruling, which is talking about the straddling of 2 constitutions. And I'll just read from here, where it says, our firm view is that it could have not been the intention of the legislature not to provide for the period that was served and that straddled 2 constitution regimes as to how it should be treated. This is so because, as stated above, a holistic consideration of the relevant provisions in this case will clearly show that the intention was or is to allow or enable a person who assumes office of president to complete the unexpired period of the term of another president to serve a substantial part of the 5-year term in office in order for that term to count as a full term pursuant to Article 1066 of the Constitution. 1066 still does include a circumstance like that of President Edgar Lungu. And in this case, it's saying the conclusion by the Constitutional Court judges and the ruling in this case was that
which talks about twice holding office. This is what is critical. These words cannot be looked at lightly. It's talking about a person that has twice held office as president. And these set of circumstances, these facts were not put before the Constitutional Court specifically to deal with those 2 key words, twice held office. What does that amount to? And again, we have to be logical and without emotion when we deal with these matters. We are risking creating a constitutional crisis, because when you then say that President Lungu never held office, what does that mean? Well, it means constitutionally, whatever he did, he was not in office. He was not holding office.
But Mr. Haimbe,
that is what I would argue.
But you also,
and it was therefore, let me just finish this point. It means he never held office. If he never held office, how was he performing the functions of president? It can't.
I know. Before we engage,
it can't in secondary school, primary school.
You did talk about
proper fraction.
In fact, you did talk about the Interpretation Provisions Act, and I would love to drive your attention to Section 16. That is under chapter 2 of the Laws of
Act of
Zambia.
Parliament. It is subservient to the Constitution.
All right. I would love to drive your attention to where one written law amends another written law. The amending written law shall, so far as it is consistent with the tenor thereof, be construed as one with the amended written law. Does that mean then that we must look at this?
No. It simply means that you must take the law as it is. Nothing more, nothing less. It means that from this point on, when the new law comes in place, then you take the new law as being as effective as the previous law.
So we take Article 106 in this case.
So no, but you don't apply law retrospectively. That's not what it means. Retrospective application of the law is a fundamental basic principle of law. You can't apply any piece of law retrospectively unless the law specifically allows you to do so. So you can't say we are going to take this provision of the Constitution and apply it so that we look at the president as having assumed office in the circumstances that this particular piece of legislation is contemplating. You can't do that. It's basic. And that is a critical question as well.
Let me give a hypothetical scenario, because I kind of understand what you mean, but let me put it for me to understand in this case. Let's say, and hypothetically speaking, would never happen. A person commits murder today. They kill someone. They are convicted. But as we are aware, the Constitution of the Republic of Zambia, the law in Zambia allows for appeals. Right? This person does appeal. In the process of their appeal,
there's a change.
The Constitution says, for example, murder is not a crime anymore. What happens in that case? Can the person continue serving their term when they be sentenced, or they can argue with the new Constitution?
They will have to be dealt with in accordance with the law that subsisted at the time that they committed the offense and were being tried for it.
Isn't that in retrospect?
No. The retrospect means that you can't apply the new Constitution which says murder is no longer a crime. That's what retrospective application means. So in your hypothetical scenario, which is a very good one, instead of saying, okay, this person killed the individual in 2015, in 2020, murder is no longer an offense. You will not come and benefit from the 2020 law. That's not how it operates.
But isn't there continuity in the law? That's what the lawyers tell us.
That continuity.
The continuity is looking at the current law.
No. It's a very, very simple concept, because what would happen? Let's look at these things, as I said, holistically and without emotion.
Let's engage Jimmy just quickly.
And I need to answer Eddie. But
exactly.
I don't want to lose that thought. What would happen is that people would change the law. Assuming I am a legislator and I have done wrong things, and I know, I'm looking at jail term. I have the power in Parliament to move a motion, a bill. I'll change the law in order to escape liability. That is what the law tries to avoid by saying you don't apply retrospectively. So if you've committed the crime at the material time, whether or not you change the law before it is your time to face it, you are going to face it. The particular.
Good evening, Jimmy. Thank you for joining us on Diamond Live tonight. How are you?
I'm alright, and how are you?
Very well, thank you. Thank you for calling. Give us your question.
I was just want to make a contribution. Yeah, you know, President Lungu was actually elected. We had the general election, and he was elected. He was sworn into power. So that is considered, that's basically a term. He never took office, but we had the general election, which he was elected as president, and he was sworn into office, which for me is actually a term. And he has served again another 5 years. Now, what will happen in 2021 if he's given another 5 years? That means you will be in breach with the Constitution. You will serve more than 10 years.
All right.
No. So now, how are we going to work with these lacunas which is in the Constitution? And I'm also happy with counsel there. Why is it that lawyers, you are not clear to explain this law? You know, the lawyers have got things to hide. You find that when you go in the Constitution, there is a lot of things which are not explained fully. You find that lawyers, it have still been a term because he came into office as a result of general election.
All right, thank you.
I think may I take this opportunity to respond to Jimmy,
Please
both Jimmy and
to
Eddie.
both of them.
I'll begin with Jimmy. Jimmy, you are enjoying your freedom to exist and to do what you want in life because of the fact that there are always different interpretations of the law. If only one side always took the day, then we would not have a situation where people get defended in court and one side prevails while the other does not. And perhaps the reason why we are finding ourselves in these difficulties is that people who are not trained, and please I'm saying this with due respect, people who are not trained in the practice of the law want to, in this day and age where we find ourselves, to become experts in the law. And so we find a situation where we start to mislead one another.
But
and
in this case,
even those who are trained...
Exactly. In this case, the people that are disagreeing with you are lawyers.
Don't forget, we live in a very divided state of affairs. We live in a very divided country at the moment, and a very political country. Because to me, it is very straightforward. We shouldn't even be having this debate. To be God honest, the mere fact is that the whole country is being governated into having this discussion because of the will of one individual. That is the fact of the matter. And I think we should go beyond looking at things that way. I think there is a moral question here. I think the will of the people must prevail. It should not be, yes, people have got their democratic rights, but they should never override the interests of the larger masses. That being said, I think you also as journalists need to take up this challenge. I think I have asked the question directly and you have avoided it. I want us to go back and ask this hypothetical question, or this real question.
I hope you're not asking us a question, because
no, we're asking the people of Zambia, they're out there, and I'll ask the question and give an answer. What is the import of saying held office? Let's not run away from that question. There's nothing else that's of relevance here. These other questions of what amounts to a full term and so on and so forth have already been answered by the Constitutional Court. Now, let us go ourselves as a people of Zambia and think, in very simple words, what is holding office twice? And you can't have your cake and eat it. I repeat this. This is the concept that I'm putting forward. You can't say for one purpose that a person has not held office, while for the other that he has. You can't apply the law. That is called selective application of the law. That cannot be done. It creates a situation of anarchy. So, if then, for the purposes of the functions that were executed by the president, he is considered to have held office, why should we split that in a different circumstance and say, no, he didn't hold office in this other circumstance? That's selective application of the law. It creates confusion. And I, as a citizen, and you as a citizen, as soon as the question then is answered that there was no holding of office because it was not a full term, then you must run to court and say, you were running the country as president, you undertook functions as president, you enjoyed benefits as president.
What?
So how can you on one hand say you didn't hold office and then on the other you held office? It's a constitutional crisis we are creating.
Let's have a caller, Matthias, who's coming in. Good evening. Thank you for joining us on Diamond Live.
Good evening.
Yes, please proceed with your contribution.
Yes, I've got a simple question.
Mm-hmm.
I take it that by the time President Lungu was signing the Constitution, he had already been elected. He was already in office. Now, when we are saying we do not apply the law going backward,